Number 25 on the calendar, the people of the state of New York versus Nicholas Brooks.
Good afternoon, Your Honors. May it please the Court, I'm Susan Wolf. Jeffrey Hoffman and I represent Nicholas Brooks. The trial court in this
Counsel,
case...
may I interrupt a moment? Do you care to reserve any rebuttal time?
Yeah, thank you. 2 minutes rebuttal. Thank you. The trial court in this case...
So what's the challenge to the fry that's preserved for our consideration?
The challenge to the fry is that there was a fry. There were motions, extensively litigated motions explaining why there should be no fry hearing, including the fact that the issues were not novel. And then once the fry hearing was granted, the judge let it go on for hundreds of pages. Defense counsel objected at the very beginning when the first witness, Dr. Catanese, was called, that the questioning of him about every aspect of the people's case and the autopsy was beyond the scope of the what Fry is supposed to determine.
If you're right, if that was all error, why isn't it harmless error?
It's not harmless error for this reason. It was a full dress rehearsal of the defense case. This was the defense witness, the defense expert. And the judge...
There's a reasonable probability that, or probability that it would have come out any differently if that hadn't happened?
Yes, it is, as with some errors, it's an unmeasurable harm, but if you look at what happened, take, for example, what if a judge had ruled that the defense could only call a witness if the people got to interview that witness first?
But are you saying the harm, then, that we analyze in the harmless error is the fact that they had this free discovery, or are you tying it to a ruling that was made at the Fry stage?
I'm tying it to the granting of the Fry and then the conduct of the Fry.
If you go to Judge Stein's question of what is the harm we're going to analyze in the harmless error analysis,
Right.
if we get there, what would the harm be? Would it be free discovery for hundreds of pages and something specific in that examination that was used, or would it be one of the judge's Fry rulings?
Well, the Fry rulings are a separate thing because they flowed from the Fry hearing. So let me just try to answer both your questions. It was an invasion of the defense camp. And what was gained by the prosecution by that was the ability, an enormous trial advantage.
But let's say this went without a Fry hearing, and I'm curious the answer here, and the witness starts to testify and the people are objecting. What does the judge do at that point? There's no foundation for this. There's no basis for this. What is the judge, there's a jury sitting here. What is the process at that point?
The judge has the parties up at the bench, hears what they have to say, and determines either that it's not admissible or that it goes to weight and not admissibility.
Why shouldn't the judge be able to have the discretion to do that before the jury's in the box?
The answer...
Based on what the filings have been, and if there's a reasonable basis for objecting to certain things, why couldn't you do that before you get to the middle of trial?
Because that would mean that in every case, you would have a Fry hearing, at which...
Well,
You wouldn't have a Fry hearing in every case. What you'd have is you'd have a motion in limine to restrict the kind of evidence that would go in, and the court would make a determination as to whether or not this witness had a foundation for the questions that were going to be proffered, which it seems to me may have been if there's an error here, the error is is that it wasn't done in that procedure, which would be a foundational procedure, not a Fry procedure. And there seems to be some confusion about the nomenclature that should be applied here, and that seems to be arguably applied incorrectly. So if that was the case, though, I guess the question we have to ask, and Judge Garcia was getting at, what difference would it make? Because if we called it foundation, and the court went forward and got a responding affidavit, and then he took some testimony to try and see if there was a proper foundation, wouldn't that be the same thing as the Fry, what was called the Fry hearing, maybe incorrectly?
Not in this case.
Why
Because
not?
the Fry hearing went far beyond
Well, you're saying
some aspect.
Slow down. So you're saying the
Go ahead.
length of the hearing then, and the amount of discovery he was getting would be much more than you would normally get in a motion in limine?
Far more.
Mm-hmm.
And it encompassed all aspects of credibility. The Fry hearing consumed more pages than the trial testimony and the cross, and it gave them a trial advantage.
Was there any cross based on inconsistent statements, for example, between what was said in the Fry hearing and what was testified to in the Fry hearing and what was testified to at trial?
Yes, there were. I believe it happened a number of times, and there were questions that weren't asked because the prosecutor was able to determine that the answer would not be favorable to them at trial. This was discovery. This was discovery that the people wouldn't be entitled to by statute, and by receiving it, they gained a huge trial advantage, which deprived Mr. Brooks of a fair trial.
Let's assume all of that's true. What I'm struggling with is why the error, assuming it was error, is not harmless, and why isn't the overwhelming evidence of the defendant's guilt here that would allow us to affirm?
Sure, and I can give you a chronology and a list of why the and I just want to add that we're talking about a right to present a defense, a constitutional error. So the standard would be
But that wasn't necessarily how it was preserved, was it?
it was preserved as objecting to the discovery and the advantage in the pretrial motions.
Point
it
is,
was.
nobody said to Judge Whitner, wait a minute, you're impinging on the constitutional right to present the defense.
Not with
Interesting,
respect to this issue.
But I don't think that was ever articulated at that level. So I want an answer to my question,
Okay.
which is, why isn't any error harmless?
Because if you look at the evidence in this case, you have two experts. The people's expert is certain of the conclusion that she presents. The defense expert testifies that there's a very important factor, which is the lack of fluid in the sphenoid sinus, which weighs against a finding of forcible drowning. He also testifies that there was an absence of certain marks on the deceased's neck, which would be there. He would expect to be there if this were a strangulation and forcing her and strangling her underwater, and as a result that she drowned. He testified that there is no way to, and I believe Dr. Sampson also testified that there's no way to tell how long those bruises had been there. Over a 24-hour period, they could have occurred, and there's no way to
Clear,
tell.
though, when you say he testified and she testified, you're talking about at the trial now, right?
Yes,
All right, so all of this is in front of the jury.
yes.
Go on.
And I'm addressing Your Honor's question of why there isn't overwhelming evidence. There was a paramedic and a police officer who discovered the deceased, who testified that they did not see injuries. There was testimony about injuries from the CPR that occurred. And most importantly, there was the testimony about how the deceased was acting spacey, in sort of a drunken, and I don't mean alcohol, because alcohol wasn't the issue, in a drunken manner, and she had said that she had taken a sleeping pill. And the jury really focused on this. And her DA was on, and her DNA was on the controls of the bathtub, the faucets of the bathtub.
And I think his was someplace also in the shower, wasn't it?
Yeah, I mean, there was a shower body apparently, and his was on one of the handles of that.
Okay.
But the water was coming out of the faucet, the handles of which her DNA was found. This is not overwhelming evidence such that had the people not had such an advantage, there would still be a conviction. And I should move to the precluded evidence, because that is as or more important, and that was the preclusion of the defense expert's testimony that he would expect to see 90% of the time a damage to a certain part of the neck if there had been strangulation.
What was the basis for that opinion he was offering?
Excuse me. The basis for that was his experience. He was an ME, a medical examiner, for 30 years. He had...
How many drowning cases did Dr. Whatley do?
He worked on hundreds of drowning cases. And based on that experience...
Drowning in which the manner of death was homicide?
I thought the record said one.
There was a forcible drowning, yes. One forcible drowning, one more than the people's expert, and hundreds of drowning cases. And
But wasn't he actually allowed to testify at trial that if the victim had been forcibly drowned, he would have expected to find this sinus filled with water? Isn't that essentially the testimony that you're arguing should have come in?
that, that's sort of a pretty wishy-washy thing to say. I mean, we, as professionals, clients, patients, they want percentages. They want their professional...
The foundation for that percentage. If he had investigated one forcible drowning, how could he where does 90% come from? Isn't that partly what the hearing was about?
It comes from the sum total of his experience. He has worked and supervised other medical examiners in both New York and Florida.
Let me ask you this. If I have a malpractice case, a legal malpractice case, and it's an appellate malpractice case, not suggesting anything, but can I just say, well, 90% of the cases a criminal defendant loses on appeal. And can I throw that out without any sort of actual study of success rates?
Experience would inform that kind of estimation, of that kind of percentage, and it's probably close to right, although I think it's
I don't know.
more.
I haven't thought about it,
But experience, an expert is allowed to give that kind of evaluation. Jurors want it. They want to know more
It
than,
has to
well,
be
what does
tethered
expect
to
mean?
something, doesn't it?
And again, it's tethered to his experience over the course of 30 years of what he's seen. And then, and there is cross-examination.
Is
And
your
that's
point
what-
that, is your point that whether or not the jury should take that into account and it weighs for something?
Right.
Is what they can explore on cross, but they can't keep you from asking him about it and him opining on it. Is that your point?
It weighs for something. It comes from an eminently credible source, and the people are free to use cross-examination to show what underlies that estimation. And a jury can weigh, well, he's a really smart guy, but he really didn't have much of a basis to say it. And it was wrong, and it was error for the judge to preclude it. And then the other important area that was entirely precluded, which was defense counsel's ability to cross-examine, question the defense expert and cross-examine the people's experts about the drug testing that was done. Imagine a situation where defense counsel is precluded from questioning the operator of a breathalyzer about whether it was calibrated. Nope, just sorry. People's witness is testified, there's no reason to question it,
Does it
you
matter
can't
that he's not a
cross-examination.
toxicologist?
What?
Does it
Excuse me?
Does it matter that he's not a toxicologist?
It doesn't, because, first of all, this isn't a new argument, it's in the appendix. It's, but not in the briefs. If you look at his CV, he was accredited by the American Board of Toxicologists. So his experience included working with toxicologists and supervising them over the course of his 30 years' experience.
Medical examiner would have a supervisory control over the toxicologists in the lab, no?
Yes, and he would be discussing cases with them on an ongoing basis. So he was qualified to give that testimony. I know that the appellate...
Aren't we basically aren't you asking us to say that the trial judge abused its discretion in determining that this area would be speculative? Isn't that essentially what you're asking us to do?
Yes, but abuse of discretion is a matter of law. There was no basis in law for the trial judge to make the rulings that she did. Defense counsel was precluded from asking any questions at all about the drug testing, and the drug test and the issue of drugs in the deceased system was extremely important.
Well, wait a
here.
minute. Wasn't Dr. Wetley allowed to testify regarding the possible sedative effects of the victim's pills and basically got the whole synergy thing in front of the jury?
Yes, and I should clarify, I'm talking about something a little bit different, which is to be able to rebut the people's position that none of these drugs would have caused sedation and would have caused her to be, in a position where she might slip under the water. And the toxicologist testified that, she seemed perfectly fine to me, even though a video showed her walking into a wall. So in order to rebut that, one, you have Wetley's testimony that the synergy between these drugs could have had the result that he described. And two, if the people are right, then there must be another drug out there, because there must be, what's the explanation for her behavior?
Thank you, counsel.
Thank you.
Counsel? Counsel, why the Fry hearing?
Good afternoon, Chief
Good
Judge Shapiro,
afternoon.
may it please the court. So, Your Honor, what the trial judge did here was perfectly consistent with what the law allows judges to do in any number of cases, and whether you want to call it a Fry hearing or, as Judge Fahey suggested, perhaps a hearing on a motion in limine, this was an...
Well, it was a Fry hearing, so what's the
Right.
basis for it?
Oh, Your-
Because your expert sees has a medical report and a medical opinion, and their expert has a different one? I thought that's what we put to the jury, to decide which expert they're going to believe.
Well, Your Honor, the trial judge has the right, actually the responsibility to make threshold rulings. First, the trial judge has the responsibility to make sure that scientific evidence, opinion testimony, which is being put before the jury.
But this is my point. It isn't the only reason that comes in contention, because the people's position is that their expert disagrees with your expert? That
No,
can't possibly be the basis for a Fry hearing.
No, Your Honor, just because somebody is a former medical examiner or is a doctor who's qualified in some sense of medicine doesn't mean that that doctor can get up and say anything in the world they want that has some relationship to the medical field. There has to be a scientific basis for what the doctor is going to say in court. And here we have a situation,
But it can sometimes be based on experience.
yes, Your Honor, and in fact, this court recognized that. And
So why wasn't that the case here?
well, here, the only things that the doctor was precluded from testifying about were opinions that were not based either on science or on his experience. And that was why it was a very limited preclusion, as was pointed out in some of
Isn't it
the...
enough to say, after 30-something years, 90% of the cases, I would expect to see that. After all, as experienced appellate lawyer on behalf of the people, you could probably predict that you would have a certain percentage of success.
And I could say that, Your Honor, because I've argued 100 appeals, or you might be able to say that because you sat on hundreds of cases, thousands of cases, perhaps. Here, the doctors wanted to say 90% of the time we see damage to the posterior central neck structures, and he couldn't even remember a case where he had a strangulation where that occurred. So this is not somebody who was saying, yes, I know.
But what if, would it make a difference if this was a foundation issue as opposed to a Fry issue? Wouldn't it really, it wouldn't really affect the outcome for you one way or the other, would it? We'd really be getting into whether or not the court abused its discretion in the way it conducted the hearing and the amount of testimony it took.
Right. Well, Your Honor, I would submit that if the problem with what happened is that the court should have called it a hearing on a motion in limine instead of a Fry hearing, then that would be harmless error.
Okay, but so let's say, it should have been called, when you want to call it a hearing pursuant to Cornell, or, any of these other civil cases, it doesn't really matter so much in my mind what you call it. How do you get to ask some of these questions that were asked for 3 days, 500 pages, and haven't we then turn this hearing into a deposition of an expert, which may be allowed in New Jersey in civil cases, but we don't allow that in New York?
Well, Your Honor, actually, to put things in context, Dr. Wetley was only on the stand for parts of 2 days during the hearing. The hearing spanned 5 days. It was not 5 full days. Dr. Wetley was on the stand for parts of 2 days. The first 2 days of the hearing, the defense didn't even bring Dr. Wetley in. They tried to bring in the other expert, Dr. Cantonese, and the only purpose of his testimony was to say, well, Dr. Wetley's analysis was fine, and you don't even have to call him at the hearing. They were trying to avoid even having Wetley appear at the hearing. Wetley was on the stand for 2 days in testimony that took about 300 pages. 300 pages, as Your Honors know, is not an excessive amount of testimony for, say, a suppression hearing, any number of pretrial proceedings, a Fry hearing in a complicated case. This is a Fry hearing in a homicide case with a trial transcript that was thousands of pages. There were very serious issues, concerns raised to the court about whether the medical testimony being proffered had any basis in science and had any relationship to this case at all, or whether it was just something that was being offered as a way to try to create some reasonable doubt in a case where there was absolutely overwhelming evidence of
Talking
this
about
guilt.
overwhelming evidence and other evidence, we've, not, just to distract you before your time runs out, on one other issue, which is of concern to me, and that is the evidence of the threat. So, didn't the people argue at trial that it was admissible as an admission to a party opponent or as part of the background hearsay exception? And if that's the case, wasn't it admitted as for the truth?
Well, Your Honor, Judge Whitner made clear at the close of the evidence that all of the victims' out-of-court statements were admitted only because she made those statements and not for their truth. So,
But never, but she did make given specific instructions to specific testimony, but not to the threat, did she?
I don't recall offhand if there was a specific comment made after the admission of the threat. I do know that at the close of the evidence, Judge Whitner made clear that all of the victims' out-of-court statements, and the way we know about the threat is because the victim made an out-of-court statement to 2 of her friends about the threat in the excitement of the moment or of the short aftermath when she had been threatened. She called 2 of her friends frantic about what had happened.
Well, weren't there, am I correct, is the number 9 witnesses testified on hearsay statements that the defendant made?
There that the victim made, you're talking about?
Yeah.
Well, first,
I'm sorry.
first, Your Honor, as the appellate division held, this was not, or as Judge Whitner instructed the jury, this was not hearsay because it was not put in for its truth. It was only put in as Judge Whitner
Well, but
instructed.
every single witness that I read here said that he was a messy, unemployed stoner.
And in fact,
All 9 of them, I think, testified that way.
And in fact, Your Honor, the defendant admitted that he loved to smoke marijuana, and he admitted that in letters he wrote to the victim.
I thought, though, it was being offered for defendants' unacceptable drug use and the breakdown of the relationship. That's why I thought it was being offered.
It was offered to show the victim's state of mind, and to show what brought her to the point where she finally broke up with him.
But why
9
are we
witnesses?
even getting that?
Excuse me. So 9 witnesses? Doesn't that seem like an excessive number? I mean, 2 or 3, and then you give a limiting instruction to the jury, but I've never seen 9 witnesses on the same point.
Well,
Offering hearsay statements.
Well, Your Honor, first, again, our contention is this was not hearsay because of the instructions given to the jury. It was for state of mind. It was not for the truth. And Your Honor, this was an exercise of discretion by the trial judge who has the control of the trial to decide in her discretion what evidence was probative and what evidence would be overly prejudicial. Here we have a situation where the defense theme was that the victim and the defendant were in a committed relationship and they just had some minor spats. What the prosecutor was trying to show was that that was not the case here. Although the victim expressed her love for the defendant at various times, she also had grave doubts about the relationship. And
Yeah, but that's very different from that statement of, I'm going to kill you, right? I mean, sort of a tumultuous relationship is one thing, where there's not some other evidence of violence or aggressiveness. But once you have that statement, isn't that the one that's, as Judge Stein said, troubles her? Isn't that the one that's extremely problematic here? And that is for its truth.
Well, Your Honor, it actually was not admitted for its truth, like all of the victim's out-of-court statements. It was admitted to show her state of mind. And it was actually a particularly important...
That she was afraid of him?
Her state of mind about what?
That she was afraid? What?
Exactly. And this is one of the reasons why it took her so long to finally...
But that's not what you argued to the jury, for one thing.
Well, Your Honor, the summation...
It was an admission.
Your Honor, the summation did argue the state of mind theory to the jury.
On the threat?
I
know it was argued on the other evidence, but not on the threat.
Well, Your Honor, it was part of the background. It was part of it was part of the background of the entire dynamic of the situation.
There's a part of the background exception in this context to the hearsay rule?
Your Honor, we're not arguing this. We're arguing that is not presented in this case. Now, there have been other cases. In fact, in people, now, this is not a hearsay case, but say in People v. Dorm, for instance, this court has recognized that the background of a relationship between intimate partners is extremely relevant and probative in a domestic violence prosecution. And it's part of the background that shows motive and intent. This court has recognized that in previous cases.
So that brings us to a different issue, which is, okay, maybe you can do that, but is that an exception to the hearsay rule? Or do you still have to get it in some other admissible form?
Well, Your Honor, if I may answer that in 2 parts, I'd appreciate the opportunity. First, once again, under the judge's instructions in this case, it was not hearsay because all of the victim's out-of-court statements were admitted just for the fact that she said them, not for their truth. Now, in the situation where maybe there is a hearsay issue, there have been cases, perhaps Birnbaum in the First Department, where the First Department has said there could be a situation where reliable hearsay could be admitted under the catch-all hearsay exception in a situation
Did the
like
appellate
this.
division refer to that case here?
The appellate division did cite Birnbaum.
Is that the only case, reported case, in which that rule was applied?
I don't believe so. I believe there are other cases,
And
but
the
I
third
don't
and fourth
have the...
department reject Birnbaum, right?
I believe that's correct. But I don't think Birnbaum is that controversial a case because it's not saying there's a catch-all hearsay. There's an always a hearsay exception for threats. What it's saying is that if you have a situation where there's reliable probative hearsay and the judge goes through the balancing analysis and says, in this particular case, under these particular facts, the probative value and the reliability of this evidence outweighs the potential for prejudice, then the judge exercises his or her discretion and lets the evidence in.
Did the judge go
Where
through
did-
that
yeah.
balancing
Where did the judge
with
do
the
that?
11 witnesses and the threat?
Well, Your Honor, in the context of this heavily litigated case, where the defense was actually trying to raise misleading impressions about the evidence, not just the evidence of the relationship, but the medical evidence as well, was trying to inject the notion before the jury that the victim was taking Ativan, which there was no evidence of, was seeing psychiatrists. That there was a lot going on in this case where the defense was trying to push the boundaries of probative evidence and admissible, relevant evidence, both in terms of the facts of the case and in terms of the expert testimony.
Sounds like a fight fire with hearsay exception.
Well, Your Honor, again, it was not hearsay, and even
Let's
if
say
it
we
w-
disagree with you, and this evidence should not have gone in. What's left to persuade us that there's overwhelming evidence of guilt?
Well, Your Honor, first, the circumstances under which the victim was discovered. She was wearing a turtleneck sweater.
By the way, was that the turtleneck she wore when she came? They didn't bring any bags, right? This is the clothes she walked into the hotel
I
with?
believe so, Your Honor, yes. She was wearing a turtleneck sweater, she was wearing a Rolex watch, and she was wearing underwear. And she was fully clothed in the bath. There was evidence that she hated baths. In fact, there was evidence that she was annoyed by the fact that the defendant would take baths in her apartment. The notion that she would walk in voluntarily to a bath fully clothed and accidentally drown was, in fact, as the defense expert witness, as Dr. Wetley said, bizarre. He understood
Okay,
that
but
that
where do you
was
get
bizarre.
where do you get the evidence that he's the murderer?
There's only one person with the opportunity to commit the murder, aside from the the hotel staff member who delivered the ice, which nobody thinks is a suspect. The surveillance videos showed that the defendant, after going to get something to eat at the restaurant, and by the way, this was after they had an argument which was overheard by a hotel staff, which might have been when the strangulation occurred, but after that point, he goes out to eat. He comes back at 1:48 in the morning. At 2:11 in the morning, the hotel receives the first report of a water leak. At 2:19, the defendant is then downstairs at the front desk where he meets David Raleigh, the bystander who he goes out and has drinks with in an attempt to create an alibi. So there's this 8-minute gap between when the water leak is first reported and when the defendant is then seen at the front desk and leaves the apartment. There's no other plausible conclusion than the fact that he was in the apartment when the bathtub was run. The timing just doesn't work any other way. For the bathtub to run, to overflow, and then for a leak to go down all the way to a lower floor and be
Counsel, from the
reported.
time of check-in to the time they discover the body, what's the period?
They check in a little after midnight, and the body is discovered at 2:51 a.m.
And counsel, the bathtub is actually physically in the room. It's not separated from the bed or anything else in the room by a wall. Is that right? There's a
Don't-
picture in the record.
Yeah, I'm not sure, Your Honor. It's a hotel room. I think it's just in the bathroom. It's just a hotel room in the bathroom. And also, so that the timeline is 12:43 a.m., they're in the room. The hotel employee, Ms. Stevens, overhears this loud argument, after which she hears nothing. 12:46 a.m., so 3 minutes later, the busboy comes to the hotel room to deliver the ice that the defendant had ordered when they checked in. He only sees the defendant. He doesn't hear or see anybody else at that point. So, and that's why there's a strong inference that at 12:43 a.m., that's when the victim was actually strangled, knocked unconscious, but not killed. 12:48 a.m., the defendant goes downstairs and inquires about, can I get food? 12:53 a.m., he orders 2 meals, has them delivered to the restaurant, but he shows up at the restaurant alone and barely eats his food and looks, according to the hotel employees, distraught. 1:48 a.m., he goes back to the room. 2:11 a.m., there's a complaint from the 4th floor about the water leak. 2:19, the defendant leaves the hotel. 2:36, there's a second water leak complaint. 2:51, the hotel employees trace the leak to the defendant and the victim's room, and they find the body. There's nobody else who goes in and out of the room. There's only one person, assuming that a crime was committed, there's only one person who had committed this crime. And that's why the defense expert goes out of his way to try to raise some insinuation, no matter how much of a stretch it is, that this could have been an accidental death, and that somehow she decided, even though she hates baths, to go into the bathtub fully clothed, wearing a turtleneck sweater and a Rolex watch, and then accidentally drowns because of a combination of drugs that she'd been taking for years with no adverse effects. And this also goes back to the judge's rulings about whether there could be cross-examination of other possible drugs. The defendant doesn't actually have any theory that there's another drug out there that could have caused this. The defendant just wants to raise speculative assertions that, oh, maybe it was this drug, maybe it was that drug. This court has held that a defendant is not allowed to put on speculative third-party culpability evidence. This is the same kind of thing. The trial judge has the discretion to say, look, under this circumstances, this is too speculative. This is just like any other evidentiary determination. If the judge determines that under the circumstances, balancing the probative value against the prejudicial effect and the general considerations in governing a trial, that there's a limit to how far you can go. And
Thank you, Mr. Cohn.
Thank you.
Ms. Wolf?
Thank you, Your Honors. There's a number of ways in which I could respond to each of the aspects of the People's case, and the defense lawyer did that in his summation. But a very important point I want to make sure to make is that the evidence from, it was 11, not 9, the evidence from these character witnesses.
By the way, did you object to the fact that there were 11 witnesses?
There was a motion in limine about this. So
What, about the number of witnesses?
not the number.
When the judge started to give a curative instruction, did you say, Judge, this is enough? Or the curative instruction isn't sufficient, or anything like that? I didn't see anything of that nature in the record.
I thought there was a lot of discussion about, how this kind of evidence shouldn't be admitted. But
Well, at all.
At all,
I thought the
right.
nature of the objection was none of this should come in, not that you can't have this much, or
I
that it's
can't.
cumulative or anything.
Right, I can't, my recollection of what's in the record on that isn't sufficient for me to be able to answer it, but
Sorry, I interrupted you.
this evidence was offered for the truth. In his opening statement, the prosecutor said, Nicholas Brooks has a history of patronizing prostitutes. In his closing, the prosecutor said, this is an unlikely couple. She was accomplished. He didn't have a job. He had no ambition. He sat around smoking, and it went even farther than that. It was presented for the truth. And not only was it the testimony of these friends, but the people called on the issue of whether Mr. Brooks had used prostitutes. People called a computer expert to show that he had accessed an adult website. They also offered texts between Mr. Brooks and his roommate, nothing to do with the deceased, about buying marijuana.
Counsel, I'd say all of that's out. You heard the people's very quick summary of the evidence that nevertheless would have shown overwhelmingly that the defendant is guilty. What's your response to that?
There was no camera and no one in that room. For things like...
But no one went in the room other than the 3 people.
This isn't an ID, this isn't a question of maybe someone else did it. This is accidental question of whether it was an accidental death. So, for instance,
That's the defendant's theory, yeah.
the people say that it's crazy that she would get into a bathtub fully clothed. Well, that is all part of trying to determine whether the drug testing in this case was sufficient, because she's clearly shown on the video as someone who's spacey and walking into a wall.
So
She
so
has-
the theory is that she turned on the tub?
The
Because
theory
she
is she
spaced
turned
out
on
on
the
the
tub.
drugs?
She let the tub fill up. It started to overflow, but you couldn't see.
She was not too spacey to know to turn on the tub and have the water run. But she
Correct.
was too spacey to stay away from falling in.
I'm sorry, Your
Getting
Honor.
in, right? Isn't that the theory? She's not spaced out enough that she knows how to turn on a faucet, knows how to turn on this tub, prepare the tub, but she's too spaced out to avoid drowning in the tub.
Because once she gets into the tub,
But she's spaced out enough to do something that everyone who knows her says this woman would never do.
that's exactly when you do things people say you wouldn't do, when you're not in in the state of mind where, you remember that you don't like certain things.
Well enough to turn on the tub.
Yes, well enough to turn it on, of course.
So when on the timeline did she die?
She died, I don't think, it's not on the timeline, because we don't know.
Where would you place it?
I would place it, there's a period of time between the time he goes to have something to eat and when they find her. Because there was testimony that you couldn't, there was a bath curtain, you couldn't see into the bathtub, and also that the water hadn't overflowed enough to have come out into the living area. So, because, I mean, of course the government, the people are going to argue it went this way, which is a series of inferences, and the defense had a different series of inferences based in a strong part of that, an important part of that, was the influence of drugs, and he was precluded from being able to develop that.
Was there any evidence in either Whetley or Sampson's testimony that would have allowed an inference that she slipped, and it was, based on the bruising or anything of that nature?
I think I recall some testimony from Whetley about the bruises and that they could correspond to someone slipping.
Thank you, counsel.
Thank you.